Ladies and gentlemen, my name is Mark Greatbatch, and it's both an honour and a privilege to be with you as your Master of Ceremonies again. This time, though, for your 30th anniversary. Having served in the Royal Navy, where I deployed on a little frigate called HMS Hermione in 1987, spending some 8 months escorting oil tankers through the Straits of Hormuz, between, as I'm sure you know, the Persian Gulf and the Gulf of Oman, I feel that I have somewhat of an affinity with you, albeit very, very thin. Now, having said that, ladies and gentlemen, it is time to get the evening underway. So would you please welcome to the stage the founder and chairman of the London Shipping Law Centre, Dr. Alika Shepherd.
My lords, ladies and gentlemen, welcome to our 30th anniversary at this magnificent venue, and special welcome for our guests from abroad. You are several, and thank you for coming. We made it together for 30 years. It feels like a long and resilient marriage, doesn't it? Thank you for staying with me this long. Tonight marks a landmark achievement of our forum. It is a joint achievement, a collective endeavor in advancing education, promoting business development, and showing to the world London's legal strength. And it is because of all of you, our members, sponsors, and supporters, that the LSLC navigated even the roughest seas during the pandemic. That gave birth to our webinars during rough seas, and you did not abandon ship. Thank you for your steadfast support, your trust in us, your contributions, and your belief in the LSLC mission. Let's look briefly back at our beginning for our newcomers and to remind ourselves what we stand for. Here is the bottom line. The idea behind the LSLC was simple but original: to create synergy in the exchange of knowledge between legal professionals, the shipping sectors, and academia. Well, 30 years ago, the shipping sectors, as you know, were operating under the shadow of their own cloisters. So it was necessary to create a space for them to meet, share ideas, learn from each other, and network. How did we start? As this is in tribute to our first president, Lord Mastill, let me paint this picture for you. I had already set up the steering committee of the LSLC. At our first board meeting at UCL, Lord Mastill asked, in a rather serious tone, you know him, "And what shall we do?" "Seminars," I said. "Naturally, but not purely academic or legal." "My dream is," I said, "to get the legal, commercial, academic, and technical experts together around the table with a glass of whiskey to discuss any issues concerning the industry and develop risk management education. That was the raw idea. He grasped the concept immediately and grasped a glass of whiskey just as fast. His eyes lit up, not just at the idea of a drink or two, but at the thought of debating and sharing knowledge. He thought that shipping was behind other industries in risk management. So, without hesitation, he supported us unreservedly. Support and encouragement from such a legal luminary, a scholar, and an outstanding judge, it was hugely important to the LSLC. So tonight, we pay tribute to our first president, to the legacy of Lord Mastill. Well, many of you were not at the House of Lords reception for the inauguration of the LSLC in 1997, either because you are too young or you had yet to join our ranks. From that time onwards, we pioneered risk management education and industry debates. In our industry 30 years ago, honestly, getting experts together from different disciplines and sectors, like the LSLC has done, it was unheard of. Now getting people together is a popular theme, even amongst politicians. Others in our industry have copied our model. Of course, it's a good model, but only the LSLC provides a neutral platform, a wide spread of experts, and our esteemed judges as chairman. So I'm really proud to say that the LSLC led in original thinking and has had a significant impact upon our industry's safety culture. Let me give you some examples. Our risk management series raised awareness in legal, commercial, operational, and technical risks, so that soon thereafter, ship owners and their P&I clubs developed their own loss prevention programs. Our Cadwallader events gave industry concerns a voice that regulators listened to. We created a platform for the shipping industry to unite, breaking down silos and fostering collaboration. Collaboration even between competitors who perform on the LSLC platform. We unveiled the hidden talents of all those who took part in our faculty, over 700 experts, over 500 seminars in the last 30 years. And by blending the vast knowledge of various experts in our panel discussions, mock trials, debates, and monthly events, we have dared to challenge wrong regulation and even some judicial decisions. All in all, we have set LSLC apart as a unique educational hub, internationally recognized as a center of excellence, and incidentally, as a marketing platform. Well, I'm not a person who likes to bellow out a populist rhetoric. You know what the sender has done for you and what you have done for the sender. So we all deserve this celebration tonight, and I hope more of you will join our ranks. Now, to the future. And what is the future? I have watched with admiration our young maritime professionals since the foundation of the YMP in 2011. They honed their skills in public speaking and leadership. That was my very purpose, to give our young a platform so they can show what they can do. And after all, it's our duty to inspire the young. And I'm so pleased there are so many young people here tonight. But the challenges ahead are immense. AI, autonomous ships, green shipping are, as you know, reshaping our industry and raising new legal, operational, and technical risks. Busy times ahead. In fact, the essays we set for the essay competition unravel these issues superbly. You will see that later. So, what we have in front of us, a new landscape for new legislation, new revised contractual terms, new types of investigation, and new questions. In fact, it's very good work for that, for our young lawyers. And it will be the task of our young maritime professionals, under the leadership of the tireless Francesca Kappa. And other young leaders from all sectors to explore the horizons of a new shipping landscape and carry forward the LSLC legacy of risk management and innovation. I have great confidence in you all and those who are not here tonight. Thank you for your innovations and your support and presenting to me that you are really the future. You made me cry. Now, a moment of thanks for our sponsors. Of course, this evening is a celebration for all of you who supported us for 30 years. But special thank you is due to first HFNW for their unwavering support as the principal sponsor again. With my heartfelt gratitude to Paul Dean and his partners. To our platinum sponsor, Floyd Zakovich. With utmost thanks to Jonathan Webb, who was really one of my very first students, and to his partners, particularly Luke and Ed came all the way from New York for this event. Thank you. To our gold sponsors, Quadrant Chambers. With my deepest gratitude also for the office space you provided to the LSLC in the last 11 years. Thank you. To our bronze sponsor, 36 Stone, for your continuous support, and special thanks to Vasandi Salvaratnam for her commitment chair of the E&E subcommittee for the last 10 years. Well, something is missing here. You may have guessed. The sponsor list would not be complete without George Chavlieri. Our silver sponsor. He's perhaps one of the few people here who have been with us from the very beginning. Without his encouraging words, never give up, we must go on, and my family's support during times of conflicting duties, I would not perhaps be standing here tonight to thank you all. Here we are. Now, my gratitude to our teams for their staunch support, particularly to our president, Lord Thomas. You have been wonderfully supportive all along. John, thank you. Members of our judiciary who enthusiastically chair our events and add value to our events. Thank you. Our council members, our directors and members of our subcommittees. Thank you all. It has been a great teamwork in organizing the monthly events. That's what it's all about, sharing knowledge. And do please carry on, even without me. And of course, on behalf of all of us here, our deepest gratitude goes to Gerard Matthews. His loyalty, dedication, and commitment over 25 years deserve an award. No event could have been organized without his efficient organizing and thoughtfulness. That's very important. He's been very thoughtful and courteous to everybody. Well, thanks to you all, I am confident that the LSLC will live for many years to come. Our younger colleagues are trained to take on the mantle. For me, it has been an amazing journey, a journey of getting to know you, working with you, a journey of service to our industry and to my adopted mother country, both of which I love. And I love you all. We also mark tonight the 101 years of the Hague Rules. Sorry to have missed the 100. As it is a topic far from easy to condense into 45 minutes, it took us a year to do that. So, and fear not, our brilliant and distinguished panelists, captain and crew will take ship command after dinner, during coffee time, so you are all jolly about it. They are instructed to navigate in good speed ahead and to steer their positions without hesitation, repetition, or deviation. Let's see if they will remember these orders. And now, bon appetit. Thank you.
My lords, distinguished guests, ladies and gentlemen, if you can, would you please stand for grace? We thank you, Lord, for this food, for friendship and fellowship. And we pray that the Spirit of God may guide all in positions of leadership in the shipping industry. For an awareness throughout the industry of the sanctity of human life, for those responsible for safety at sea, and for those involved in the training and welfare of seafarers. Amen. My lords, distinguished guests, ladies and gentlemen, it is now time for the Lord Mustill debate, Hague 101 Reflections. Ladies and gentlemen, the speakers, the Honourable Mr. Justice Foxton, Sir Bernard Edder, Simon Rainey, KC, and Timothy Young, KC. Can I remind the speakers that they must speak without hesitation, repetition, or deviation, and that they must finish by 10 p.m.
I thought we'd finish in about 5 minutes. Oh, so sorry.
So we've now reached that part of the evening called the Lord Mustill debate. My name is Mr. Just Foxton. I owe my presence up here to a hard-won reputation for never saying no to a free meal. There are some organisations that at this point would try and fob you off with 3 tired, burnt-out hacks, desperately trying to rescue their careers from the death spiral they have entered and look for one last shot at the big time, but not us tonight. We bring you 3 tyros in their prime, desperate to slug it out.
Vote for me, vote for me.
Now, the format is going to be that each of them, following a very polite and respectful introduction from me, they're going to talk to you about a shipping case, hopefully with a Hague Rules connection, that they will argue and seek to persuade you is one of the most interesting and exciting of all time. I hope along the way there will be a chance for some reminiscences about Lord Mustill, after whom this debate is named. And then there is going to be a brief moment of audience participation where you will get to decide who has won. Now, we are going to begin with Mr. Simon Rainey. From Quadrant Chambers, or as it will always be for me and those of us of a certain generation, to Essex Court.
Yeah. Quite right too.
Simon's nickname when I was at the bar was Brainy. Before he gets too pleased with that, remember Robin Hood's Little John was not so called because of his diminutive stature. He is one of the leading advocates in shipping litigation with a remarkable near monopoly of cases in the Supreme Court. And I was very keen to come up with a surprising fact about him for you all tonight. And after great diligence, I discovered one, which is that Simon is a Deputy High Court judge with a commercial court ticket. Well, it came as a huge surprise to me, I have to say. Because in my 2 years as judge in charge, I don't remember seeing him set foot our side of the Rolls building.
His fingers are too hard.
I think that word had reached him that the daily stipend wouldn't buy him a bottle of his preferred claret. It's all a matter of perspective, Simon. That is still more than a lifetime's royalties from the law of tug and tow.
Shall we go down now?
That is a book that has not troubled the Amazon top 10 list, even in the tug and tow category. And if you read the comments, most of them are from disappointed purchasers who thought the book was about some obscure sexual practice. But from tug and tow to time bar, Simon.
Thank you very much. The case I want to talk about tonight is the most recent decision of the Supreme Court on the Hague and Hague-Visby rules, Finback and KCH, the Giant Ace, decided last year. The challenge was set you need to make Article 3, Rule 6 of the Hague and Hague-Visby rules funny. It's a challenge which I'm not going to attempt to take up because it's not really a very, very humorous topic. But the issue in that case was, does the time bar in Article 3, Rule 6 of the Hague-Visby rules apply to misdelivery by the carrier taking place after discharge? The reason why it's so appropriate to talk about this tonight is it started off as a preliminary issue in arbitration. Here are two of the arbitrators, and you'll be glad to find, I think
Julia is over there.
Julia Dias is over there somewhere, now Mrs. Justice Dias, who chaired the tribunal. And the question before the arbitrators and the courts was one which was left unanswered by the decision of this man in the Al-Hani, because in the Al-Hani, the court had to consider what Article 3, Rule 6 meant in the context of misdelivery claims, and done a lot of the heavy lifting, because David Foxton, QC as he then was, a younger version. I've compared the website photograph of you on Essex Court Chambers with the one now in the Commercial Court.
Public service is not kind, Simon.
And he rejected the argument that Article 3, Rule 6 of the Hague Rules time bar only applied to breaches of the rules themselves. And he held it applied to all breaches, whatever, of the carrier's duty. And then note these words, because these words were effectively cribbed by the Supreme Court in their decision, which have a sufficient nexus with the goods to be carried. But unfortunately, in that case, or fortunately for me, misdelivery took place simultaneously with discharge. So he didn't have to decide whether the Article 3, Rule 6 time bar, that was a Hague Rules case, applied after discharge. That question then came to be addressed 4 times. The stellar arbitral tribunal, which I've mentioned, said that Article 3, Rule 6 of both sets of rules applied to matters after discharge. Commercial Court, Sir William Blair agreed. The Court of Appeal agreed, come to that in a minute, but only in relation to Article 3, Rule 6 of the Hague-Visby rules and not of the Hague rules, where the position was said to be different. And the Supreme Court then restored the tribunal's decision. Why I want to commend this case to you for my vote this evening is because I think there are 3 aspects of importance and interest showing the Commercial Court and commercial judges' modern approach to the construction and effect of the rules. First of all, the Court's analysis of the language of Article 3, Rule 6 of the Hague Rules, both Rule 6 itself, but also of often forgotten parts of Article 3, the Article 3 obligations, for example, in relation to issuing receipt for shipment bills, Article 3 obligations in relation to the tallying of the goods after discharge but before delivery, all things which are normally not really considered in the textbooks, but which are really focused on by the Supreme Court. Secondly, and critically, I think, the Court grappled once and for all with the so-called period of responsibility argument, something which is often loosely cast about and often not, I think, properly understood, but i.e. the argument that the rules, all of them, apply only to a temporal period, starting with loading, ending with discharge. Other than that, the rules have no application. Time bar, presumably limitation of liability as well. And that was first enshrined in the Goss-Millen decision, Mr. Justice Wright, in 1927, based on Articles 1E and Article 2. I don't have time to tell you about the very interesting diversion which the tribunal took. I know, okay. Where they took a very novel view about whether there was a chronological sequence or not under Article 1E and Article 2. The Court of Appeal, the leading judgment given by Lord Justice Males, considered that for the Hague Rules at least, those articles created a nest. It was their word, not mine, a nest. And that to give Article 3, Rule 6 a post-discharge application would effectively introduce a cuckoo in the nest. Again, Lord Justice Males' graphic and memorable words. The Supreme Court's analysis explained that the period of responsibility defined only the scope of the obligations, but did not apply to cover provisions such as Article 3, Rule 6, which were plainly, and Article 3, which were plainly intended to have some sort of application between discharge and delivery. And the third important feature, I think, is the use and utility of travaux préparatoires. You look at me. Do I look like a darts player?
Yes.
Triple top.
100.
And I've never played archery, but I seem to spend a lot of my life, professional life anyway, in Lord Steyne's words in the Janus K, trying to score a bullseye with the travaux. I failed dismally in the Jordan 2,
Oh, it was a great case.
in relation to Article 3, Rule 2. And both Tim and I bombarded poor old Michael Burton with slabs of Stirley and Berlingeri in the Limnos on Article 4, Rule 5a, prompting him cheerfully to remark, not even considering the arguments in his judgment, there's always something for everyone in the Hague Rules Travo. But the position is perhaps different for the Hague-Visby rules because the remit to the drafters there was very focused, 5 specific questions having been defined in the, I'll mention them now because no one will ever mention them again, the Rijeka Conference and the Stockholm Conference, and the change of the language to much, much wider language, specifically to deal with misdelivery. I achieved an ambition of a lifetime, sad aren't I, when the Court of Appeal held that the Hague-Visby rules Travo showed that I had scored a very clear bullseye. That was it. I could relax. The Supreme Court reached the same view. It reached for the Hague rules. It didn't need to consider the Travo in the same way, but essentially agreed. And so the result is, and I think this is a very important result, not only for Article 3, Rule 6, but I think the next interesting question will be what happens to package limitation, that Article 3, Rule 6 in either rule applies to, borrowing David Foxton's words, all breaches of duty before loading and after discharge which have a sufficiently identifiable nexus with the goods carried. And there is an interesting connection with Michael Mustill, because Michael Mustill wrote the first commentary on the Visby Protocol in 1972, in an article which is very difficult to track down, but which shaped the views in Scrutton in the next edition after the Visby Protocol in 1974. His firm view was that Article 3, Rule 6 would never apply to misdelivery, because it was a very serious breach. But of interest was his dismissive rejection of the Hague-Visby rules Travo, which I just mentioned scored a bullseye, in which he said, these are mere fragments of deliberation giving no or little guidance. Anthony Diamond, in his seminal article relied upon by the Court of Appeal and the Supreme Court, disagreed, and other commentators have disagreed as well. And I think this case shows, Court of Appeal particularly, but also in the Supreme Court, the shift in a more modern and receptive way to using the Travo preparatoire for the Hague rules and the Hague-Visby rules. It happened in the Equasia in relation to the meaning of unit in Article 4, Rule 5, and Andrew Popplewell's use of the Travo in the Lady M on Barratress fire in relation to Article 4, Rule 2b. Although I leave you with these words, the Court of Appeal disagreed with his approach, and they said that Glencore's argument not only failed to hit the bullseye, it should never have been aimed at the target. So that's, I think you should vote for the giant ace.
Now, after that very strong opening, we move to Mr. Tim Young, KC, 20 Essex or 3 Essex Court.
Yes.
Yes.
One of the most feared opponents at the commercial bar, and indeed feared by any judge without a shipping background on any Section 69 appeal from a shipping case, where they will be told that were they to reject Mr. Young's submissions, the entire shipping world would be in despair.
Voyage charters would have an adverse footnote.
Yes. Well, Tim, as he's managed to work in, one of the co-authors.
It's very good value at £565.
Yes, excellent work. Voyage charters.
And much better reviewed than Tug and Tow, I have to say.
Much better.
Voyage Charters is not the only work of literature in which Tim's name features.
True.
There are a series of novels set in an oversexed barrister's chambers called the Caper Court series by Caro Fraser, one of which is dedicated to Tim Young QC, the Scrutton of his generation.
This is true.
No, I can't see it either, but I first came across Tim in a courtroom in a case in which I was Bernard's pupil, the Dominique in the House of Lords, of which we will hear more later. Tim was being led by Martin Morbick. Martin finished his submissions as respondent, and Lord Brandon, I think, asked the entirely formal question, did Mr. Young wish to follow? To everyone's surprise, I think particularly to Martin's surprise, Tim did, and proceeded to treat us to a very learned discourse on how the regnal years of the statutes of set-off translated into the Gregorian calendar. The next morning, Bernard was all set to go in reply when Martin said, could I have 5 more minutes? and he proceeded to get up and make a series of corrections to Tim's submissions of the original form.
Martin.
But my own great memory of Tim at the bar came when I started the longest case I did, and the court was thick with that first day of long trial tension. The partners from the solicitor firm had all turned up, the directors from the client, and then suddenly the doors swung open at the other side of the super court, and in walked Tim. The room fell silent, and he looked in my direction and said, "Foxy old fruit." So from one old fruit to another, Mr. Tim Young.
Having just heard Simon's very erudite account of the giant ace, two thoughts come to my mind.
Can I leave now?
One is that much as I sat listening to him in the House of Lords, as it then was in the Jordan too, going on for 2 days about the travaux préparatoires, I was thinking, God, I really don't have any answer to this. I really don't know what to say. And I've got that feeling again now.
But you forget Lord Steyn said Simon Rainey conducted an extensive tour d'horizon.
I would
travaux, and then
I was going to say that fortunately, Johann Steyn did say, Mr. Young, we don't need to bother you, which sort of was a bit of a relief. When Aleka asked us all to debate this evening, she said she wanted us to do a learned talk. Well, you've heard one. She said she wanted us to talk about Michael Mustill, which we will do. She said, but be funny and do it in under 10 minutes. And Gerard Hopkins, who is sitting over there, said that it should be done in under 3 minutes, which I'm going, I hope, to do. But could I?
3 minutes.
Yeah, right. Could I first of all just say what an absolute pleasure and a privilege it has been and is to be here with Lady Mustill, who is sitting here now, and I think we should all give her a round of applause.
yeah.
That's hearing the giant ace talked about, we, the tribunal, did try and keep Simon on his best points. But as the case went up, there was a Chambers Christmas party, I think it was. And I was chatting to my dear old friend, Stephen Mayles, who is here somewhere. He's not going to admit to it.
He's over there.
Oh, he's over there. Oh, yes. Who said, you do realise, Tim, how it's stuck in the craw to say that you were right. Whereupon Nick Hamblin, Lord Hamblin of Kersey, said, you don't know how much it's stuck in the craw to say that you were right, Stephen. But the truth is, nobody knows how it's stuck in the craw to say that Simon was right. Now, Bernard and I and Julia Dias were on the tribunal, and Simon just about didn't manage to lose it. And you would have thought that was the single most important case on the Hague Rules that we're going to vote for. And what are we here for today? We are here to debate which is the best case on the Hague Rules. It's a sort of strictly come judging. David isn't really quite Claudia Winkleman, but you know what I'm saying.
Oh, I don't know, from this aspect, I think.
Tess Daly, perhaps. But so I'm here to proselytize for a different case, which is the CMA CGM Libra, which, there was a mutter of knowledge there.
Excitement.
Some people would know about it because we've got Nigel Tier, who was the judge at first instance. A big round of applause for Nigel Tier. Hooray! We've got Stephen Mayles, who upheld him, admittedly with others, and we've got Lord Hamblin of Kersey. And it has to be said, after the CMA CGM and the Giant Ace, you have to say that Lord Hamblin is very rapidly becoming Mr. Hague Rules, or should it be Lord Hague Rules? But the one that he decided was the CMA CGM Libra, was the great battle that you may remember. Those of you who study the Travaux Préparatoires will remember at the Hague Rules conventions, it was when the British ship owners took on the rest of the world, largely Americans and French, about how to deal with some of the terms that had crept into bills of lading. And it was the great battle between seaworthiness and seamanship. And this was at a time, 1924, when radar had not been discovered. Echo sounders had hardly been discovered. The first patent for an echo sounder was in 1915. And the first ship that actually had an echo sounder, a Fessenden oscillator, as it was called, was in 1924. It was the SS Berkshire. So the draftsman of the Hague Rules had no idea about these clever things. And it's quite important when you think of how the Supreme Court in the United States have considered the US Constitution, that you've got to look at it, you've got to construe the convention or whatever it is in the light of the thoughts of the original draftsman. Well, the original draftsman of the Hague Rules would have had no idea about any of these things, and they wouldn't have had any idea about the IMO, which came into existence a lot later and generated some regulations in 1999 about voyage planning, passage planning. And it's passage planning berth to berth, even when there's a pilot on board. Now, in the CMA CGM Libra, it was, in a sense, it was a doddle of a case, as Nigel Tier would agree. Ship coming out of Jammen, barely a couple of miles out, grounds. Held, bad passage plan. But passage plans go from berth to berth, and one berth can be 12,000 miles away from another berth. The voyage in question can be to one port, China, don't know which one. There is a host of difficulties which have yet to be confronted. There is a host of problems with changes in passage plans. But that is all then under the heading of Article 4, Rule 2A of errors of navigation. But this was seaworthiness. And the Supreme Court, Court of Appeal, first instance, all held that a passage plan goes to seaworthiness. They haven't yet begun to consider the difficulties that can arise. And I'm pleased to say that for the lawyers here present, there's ample scope for development. But the point that I want to make is that the Hague Rules showed have showed in the intervening 100 years how modern developments can still be embraced and still give the Hague Rules some purpose. And there were three things in the news last week which set me thinking. One is the death of Frederick Forsyth. Two is that... Yeah. Do shut up.
Chairman, would you mind restraining that table?
They're a rough crowd over there.
They are a very rough crowd.
You will hear the death of Freddie Forsyth, that Uber are going to produce robo-cars run by AI, which from the countryside where I come from, that was artificial insemination. But, yeah. And the third,
just gone down.
well, The third was, if you noticed, there was a collision in the Straits of Hormuz when a ship was hacked. Now, one of the fascinating things about Freddie Forsyth was that he wrote a book called The Fox, which was about the
Hague Rules.
Shut up. It was about a hacker. It was about a hacker, a schoolboy hacker, who was employed by MI6 to ground a new-build Russian warship on the Goodwin Sands. And it sort of set me thinking that will seaworthiness in due course, when ships are being navigated by artificial insemination or whatever, will the obligation of due diligence engage anti-hacking? And I have absolutely no idea, and I'm sure that Lord Hamblin will have long since left the Supreme Court by the time the issue gets up. But it's going to be there. There are ships that are colliding. These ships that collided in the Straits of Hormuz really had no idea what was happening. So I think what has happened is that the Hague Rules have shown that they are still useful instruments 100 years on, and that we, the English lawyers, have got the ability to adapt and develop them to changing circumstances. And that is why I suggest the CMA CGM Libra is the single most important case. And I would heartily urge it upon you. Make the Hague Rules great again.
That brings us to our third and final debater, Sir Bernard Eder. We're continuing The Only Way is Essex theme because Bernard conducted his 30 years or so at the bar for Essex Court. Bernard has contributed to commercial and shipping law in many ways as barrister, judge, arbitrator, and author. He was the general editor of 2 editions of Scrutton. There are some younger members of the audience who don't know who Scrutton is. Let's just say he was the Tim Young of his day.
Actually, I'll tell you the background of that.
It is widely recognized that Bernard's greatest contribution to commercial law was being my pupil supervisor.
Yeah. Pupil master, isn't it?
My abiding memory of him is how incredibly hard he worked. And he used to get through pleadings at the most phenomenal rate. But Eder pleadings were incredibly economical documents. It's always said the Delphini got to the Court of Appeal on 2 non-admissions and a general traverse. And on one occasion, it emerged that Bernard had settled points of claim and points of defense in the same action. He was very consistent. His points of defense said his points of claim didn't disclose a cause of action and were vexatious and oppressive. And there was another occasion when he was arguing a point on one of the principal clauses in a leading form of charter party. And he got so into the argument, he suddenly realized he did not know which of the rival constructions was the one that favored his client's case. So when I am asked what Bernard's qualities as an arbitrator are, and there are many, I always say principal amongst them, and it's a great quality in an arbitrator, is he can never remember who appointed him.
Thank you, David. I'm going to correct, the last joke was not correct, but I'm going to correct the first one, which was about the Dominique and Tim Young, if I may. And David didn't quite get the humour of it, if I may say so.
And it was untrue.
Well, there we were in the House of Lords in those days, with Lord Diplock sitting in the middle. And as David said, Martin Morbick, QC, at that stage, was just was in the middle of argument. And he was talking about the Common Law Procedure Act, 1861, I think. And Lord Diplock says to Martin Morbick, could you tell me when that act was repealed? And Martin's
Relief Act.
Debtors Relief Act. And Martin Morbick said that he didn't think he could answer the question. And we passed on. Martin Morbick got to the end of his submissions and then sat down. And in the usual way, Lord Diplock asked the junior Timothy Young, not QC, whether he wished to follow. And the standard procedure is that the junior lifts himself slightly, bows, and sits down. Not Tim Young. Oh, I do, he says. Goes up to the middle of the lectern and says, "Your lordships may recall that my learned leader was unfortunately unable to assist your lordships on the crucial question as to when the Common Law Debtors Relief Act was repealed. I am pleased to be able to tell your lordships that I am able to assist your lordships." And I forget what he said, that the act was repealed or something or other in some date, I think 1920 or something. And Lord Diplock knew what was going on. He's very grateful, Mr. Young. Thank you so much. Anyway, Mr. Young goes back, and the next day I'm on my feet, but as David said, Martin Morbick comes up to me and says, "Could I just say something to their lordships in the middle of yours?" I said, "Fine." So Martin Morbick then goes up and says, "Your lordships may recall that my learned junior sought to correct me yesterday and informed your lordships that this act was repealed or something on this particular date. I regret to inform your lordships that my learned junior was in error." And he then corrected him. Well done, Tim. That's the true story. You have no right of reply. No right of no right.
I've heard the witnesses, and I simply don't remember them like that at all.
I'm going to start, if I may, with a short story about Michael Mustel, who, for those who didn't know him, was really a great, great man. And when I say a great man, I mean not only a great lawyer. He was one of the kindest people I ever came across. And he was a wonderful man with a huge range of interests, with an enormous sense of humor and humanity as well, but humor. So I did a very big case, almost 50 years. This is my 50th year in practice, I should say.
Never tell.
No, I started on the 1st of October 1975, so I'm nearly there. But I did a very big case where I was led by Michael Mustel, Basil Eckersley, Ian Cannell, and I was the baby junior. I think I was 25 at the time, something like that. And it was a shipbuilding dispute. And on the other side was Tom Bingham, Brian Davenport, Mark Potter, and Jeremy Cook. And Jeremy and I were the baby juniors in that case. And it was a very big shipping dispute. We were down in the city. And on the first day of the hearing, Michael Mustel arrived with 2 big carrier bags. He walked down like this, 2 big carrier. I thought he'd brought some books or something. Anyway, he opened one of the bags, and inside were about 20 white T-shirts. And printed on the front was the name of the ship, which was Hull 1016, in big black letters with a ship's wheel in the middle. And underneath it said, "Good guys," in big black letters. And he handed them out to all of our team, to Basil, to Ian Cannell, the solicitors, and to me. And he said, "Look, when I open the case in half an hour, I want you to put the T-shirts on, and in the usual way, I will introduce our side, and I want you to put the T-shirts on, wrap your jackets like that, and I will say to the tribunal, including Sir Pat Neal, who didn't have much of a sense of humour, that in this matter, we act for, and I want you all to open your jackets like that." And I said, "Okay, great, but what have you got in the other bag?" "Oh," he says, "I'll show you." And inside the other bag were 20 black T-shirts with white writing on it, virtually exactly the same, Hull 1016, ship's wheel, and underneath it, it said "Bad Guys." And he said, "I'm going to give this to Tom Bingham, and I'm going to ask him to put them all on his team. And when he introduces his team, he can do that and say he acts for the bad guys." Anyway, he took these over to Tom, but I'm afraid Tom didn't have a very good sense of humor. That did not go down very well at all. But that was, it showed, it was a very big case, and I'm sure Jeremy, I think, may remember it. And I'm very pleased. Jeremy has become a great friend over the years, and we do a number of arbitrations together, and he is fantastic. Anyway, thank you, Jeremy, for being that friend over the many years. I did 3 cases in front of Michael Mustel as a judge. I'm not going to go into 2 of them, but I am going to mention one, which is called the Dominique, which was about the Hague Rules, in a way. There was a claim for freight, and it was a simple claim for freight. It was rather complicated because a bank was involved, and the claim for freight was not by the owners, but by the bank as assignee. That was a wrinkle in the case. But there was basically a claim for freight. And there was I'm going to call it a cross-claim, that's important, for damages for repudiation. And the problem in the case was for wrongful repudiation by the charter against the owners. And the cross-claim for damages for wrongful repudiation exceeded by far the claim for freight. That was the main issue in the case. Now, the thing is that the cross-claim for damages for wrongful repudiation was brought more than 12 months after the date when the goods ought to have been delivered. And that claim was in principle time-barred by the Hague Rules. The question was, however, could that claim be maintained as a set-off by way of defense against the claim for freight, even though that claim, if pursued as a cross-claim, counter-claim, would be time-barred? And Michael Mustel's judgment on that issue was completely brilliant. I should say I won before Mr. Justice Hobhouse, and I lost before Lord Justice Mustel in the Court of Appeal. But it is still a brilliant judgment. The one thing I did learn in the Court of Appeal from Michael was I referred him to a case, the course to a case, and he asked me about something in the argument in the case. And nowadays, we don't look at arguments anymore because they're all on Bailey, unfortunately. They're not most of them are not in the proper law reports, not in the big cases. And I had not read the argument. It was a very old case, and I had not read the argument. And I'm afraid to say he got rather cross with me in the court, in a nice way, but he said, never, ever refer me or the court to a case unless you have read the argument. And that has really taught me a lot about Michael Mustel. And Michael Mustel was such a great man. He always used to say, I used to complain about the young people in chambers used to complain about how much hard they worked. He used to be a pupil. He told the story of, perhaps Bernard Ricks may know this better than me, but this is a story he told me, that Michael Mustel, used to be Alan McCatter's pupil. And Alan McCatter used to work very late in chambers, but he always required his pupil to remain in chambers until Alan McCatter, went home. And the other rule that Alan McCatter imposed, said Michael Mustel, was Alan McCatter would not allow Michael Mustel in his room. So Michael Mustel would wait outside and often sleep on the doormat outside Alan McCatter's room until maybe midnight, when Alan McCatter would go home. So if any pupil or young barristers are not here complain about how hard they work, it is nothing compared to what Michael Mustel used to do. Now, the importance of this case, you must vote for this case, because I won it in the House of Lords. Simple.
That sounds a very bad reason.
It's the best argument. It's the best argument.
Can I just say, watched him. No, shut up. I watched him, and he was absolutely brilliant.
Oh, you can say that. That's fine.
And he took silk very shortly afterwards, and frankly, with some justification. He was stunningly good, and he probably won't be able to tell you that, but I can.
Well, the problem was that Gordon Pollock was supposed to lead. I did it in the Court of Appeal, and Gordon Pollock was supposed to lead me in the House of Lords. I was still a junior. And Gordon, for reasons I can't remember, was overrunning, I think, on another case. And therefore, a week before the case in the House of Lords, he abandoned me. And I did the case in the House of Lords. Martin Morbick, I don't think he is here, is convinced and has always told me that the House of Lords got it wrong in the Dominique. But that is a
They
fact.
didn't know the correct date of the Debtors Relief Act.
But that doesn't matter. It is a great case because it's a very simple case. Can you set off against a claim for freight a cross-claim for wrongful repudiation of the Charter? Everyone, I think, certainly in my chambers, was absolutely convinced that Michael Mustell was right and that we had no chance in the House of Lords at all. But we did reverse it. Well, I reversed it, I suppose. But anyway, we reversed it. And it is a great case to show that however difficult a case may seem, our job as lawyers and barristers is to fight a case as hard as one can, in the best way possible, I hope. And a case that might seem hopeless may still be a winner. So I think you should vote for this case because it gives hope. It gives hope. And hope is the essence of life. And I beg you, please, to vote for the Dominic.
I think I might vote for you myself.
While that rising tide of desperation subsides, Tim, do you have any reminiscences of Lord Mustell that you can share?
Yeah, actually, I do.
I do.
The Niedersachsen, which was a case where Bernard was on the other side. It was a ship sale dispute, and it was against the buyers were Emberikos, or at least it was a company of which Mrs. Emberikos was the chairman and president. It was an application for a Morava injunction, and the entire board of Emberikos were on one side. There was Bernard, and he had, I think, a leader and about 6 partners from Inces on one side, and there was me on the other side with Peter Scrace of Holman, Fenwick and Willan. And in comes Mr. Justice Mustell, and he looks at this assembled mass. He says, Mr. Young, he said, you look a bit lonely over there. Shall I ask some of the people at the back to move it? And they all look absolutely terrified.
Now, Simon, I think that you may actually have marshalled for Lord Mustell in your salad days.
I did. When I was fortunate enough to be Richard Aiken's pupil, he arranged for me to marshal with a commercial court judge. He didn't ask me whether I wanted to marshal for a commercial court judge, and told me about a week before I went up to marshal that I was going to go with Mr. Justice Mustell, which scared me quite a lot because he was plainly a very distinguished commercial court judge, and I was in my first 6 months. And I went up to Newcastle, where he was sitting in crime, and as Bernard has said, although I was very daunted by it, I met a man who was fantastically friendly, very, very warm, very, very kind, very, very funny, very, very funny. He was plainly very much at home in Newcastle. He liked Newcastle. I've been talking about that with Lady Caroline this evening. It was one of his favourite crime venues, and he was fantastic with juries. Really, really understood how a jury works. We did some awful trials, but he was really very good with them. But it was that sense of fun. And when I went up for pupillage, for marshalling, the Crown Court in Newcastle then was in the old Moot Hall, which looked out over the River Tyne, and you could see all the 3 bridges, the high level, the railway bridge, and this little rotating swing bridge. And we would have lunch in the room, and he said, I've never seen that open. Marshal, go down to the bridge and see when it can be opened, because there's very little maritime traffic. Now, as a marshal, I don't know what marshals wear now, but I was told that you have to turn up striped trousers, black jacket, bands. So I went down from the Moot Hall to this little swing bridge and said, I'm coming from the judge up in the Moot Hall. He'd very much like to see the bridge open. And the bridge keeper said, oh, I'd love to open it. Well, I really, really would. Sorry for my accent, it's General Northern. And so he said, what time would you like it open? And so I said, what about 1:05 tomorrow? And so we all trooped out, Michael Mustell in his red robes, and he was, I won't say he was like a child, but he was so gleeful. Look, it's open. So it was that spirit of fantastic fun, illustrated by Bernard's story about the T-shirts. I mean, and you couldn't reconcile that in a way with this sort of mega force in commercial law, this, when he was sentencing, very, very stern criminal judge. Very
Now, alas, all fun has to come to an end at some point, and we're now reaching the serious point in the evening. This is going to be, the winner will be decided in a very scientific method, which is I'm going to announce them one at a time, and the amount of noise you make will determine the winner.
Loudometer.
The most noise, obviously, being the winner.
Green would love this.
So if your vote goes to Brainy Rainy from number 2, make some noise now.
Very quiet over there.
There is a party free element. There's a very loud party free element over
They
here.
paid him a lot of money.
If it's Old Fruit Tim from number 3, then now.
I know he's going to bring the house
If
down.
it's both sides Bernard from number 4, now. I think almost as big a surprise win as the Dominique itself. Anyway, that completes our part of the evening. Thank you for your time and attention.
Thank you very much.
Well done. Well done, Tim.
My lords, distinguished guests, ladies and gentlemen, would you please welcome to the stage Sir Nigel Tier.
It is with great pleasure that I announce the winners of the essay competition. We now come, I regret to say, to the serious part of the evening. The topics on which essays were sought included autonomous shipping, green shipping, and bulk carrier casualties. 28 essays were received from the United Kingdom, New Zealand, and Singapore, from India and Indonesia, and from Spain, Greece, Brazil, and Albania. They were of a high standard, and all entrants to the competition are to be congratulated. There was a judging panel of 7, including myself. I am very grateful to the judging panel for its careful marking of the essays, which resulted in a short list of 8 essays. Judging the eventual winners, though difficult, was a pleasure. Speaking for myself, at any rate, I learned a considerable amount from reading the essays on the short list. I shall announce the winners in reverse order. In 4th place is Aditya Sushant Jain from India. His essay is entitled An Autonomy Innovation Liability Optimization Model for Maritime Autonomous Surface Ships. This was a truly novel and innovative approach to the liability of software developers and remote operators unable to benefit from the limitation of liability available to ship owners. It proposed a mathematical formula for assessing liability based upon the total social cost of their work, taking into account risk deterrence, innovation incentives, and insurance feasibility. When legislators have to address this subject, they would be well advised to consider the philosophical basis of this novel approach to liability, and perhaps to seek assistance in understanding the mathematical formulae which it is suggested can give effect to it, something which neither I nor I suspect the judging panel were able to do. In 3rd place is Geoffrey Duckworth from the United Kingdom. His essay is entitled "Greener Shipping: Is the Shipping Industry Succeeding in Achieving Its Goals, and What More Can Be Done?" This essay examined the 2023 goals set by IMO to reduce greenhouse gas emissions from shipping. The incentives to ship owners to reduce emissions by 2030 are discussed and analysed, and the alternative fuels which would be required to meet net zero by 2050 are comprehensively described. The author is to be congratulated on his critical assessment of IMO's targets. Whether IMO would approve of his criticisms, I do not know. But I understand that Geoffrey Duckworth is here tonight, so could he please come up to collect his prize? Congratulations indeed. Well done. In second place is Iris Ng from Singapore. Her essay is entitled "Safer, Greener and Leaner: The Impact of Autonomous Shipping on the Shipping Industry." This essay assesses the likely place of autonomous shipping in the industry in the near future and suggests with some force that it will be a rather modest place, a conclusion which might be disappointing to some. The essay then examines whether autonomous shipping should be subject to fault-based or strict liability, and suggests the former. The essay is an impressive and critical addition to the existing literature on the subject. And finally, I come to the winner. The winning essay is very much up to date and addresses the approval by IMO in April 2025 of the legally binding framework for reducing greenhouse gas emissions from shipping to be adopted under MARPOL. It examines in particular the two-tiered emission pricing mechanism and its contractual implications for time charters in English law. The author concludes that there will be a need to reflect in time charters the financial and regulatory consequences of operational decisions regarding speed, routing, and choice of fuel, and how the risk of such consequences should be allocated between owner and charterer. The essay gives a most interesting insight into the legal issues which we can all expect to meet, either in arbitration or in court, in the coming years. The winner is Lucia Diaz Camisel, who was a student at the Spanish Maritime Institute. I congratulate her and ask her to come and collect her prize.
Ladies and gentlemen, now for the surprise. Ladies and gentlemen, can we again please show our appreciation for Frederica, Martina, Isabella and Rosa. They are Les Muse Luxury Events. And ladies and gentlemen, they've flown in today. In fact, I believe you flew in this afternoon from Italy just to perform for you this evening. So please, one more round of applause. Ladies and gentlemen, would you please welcome to the stage the Right Honourable, the Lord Thomas of Cumgeath.
I'm not sure how I obtain the silence necessary for me to perform my duty. And I think I can do that almost in one sentence. And that is to say, thank you, Aleka, for such a magnificent evening. But one sentence could not possibly express the gratitude of us all for the huge achievement that has been brought about over the past 30 years. The objective has been set out, the achievement you know about, the hard work that's been done, and as important, the fun that has been had as we have witnessed throughout this evening. But how has it been done? First of all, there was vision. Secondly, there was determination. Thirdly, there was colossal energy. And fourthly, the ability to get everyone to join in and for no one to say no to any request. I've yet to meet anyone who said no. And thirdly, and fifthly, it was all done in the interests of us all in a way that is perhaps unique. It's done selflessly for the London maritime community, the worldwide maritime community, and to the benefit of us all. This is Aleka's singular achievement, and we are all profoundly grateful. And if I am to thank the London Shipping Law Centre, really the thanks must go to Aleka for all she has done in those respects. It's been a wonderful. And before I ask you, as I shall in a moment, that we ought to drink her health, I just wanted to reflect on would this have been an achievement of which Michael Mustill would have said, this is exactly what we envisaged 30 years ago. And I think he would have said yes. Firstly, he was one of the great judges of his time and had a profound understanding of not only commercial law, but also of other areas, particularly criminal law. And he knew, with that profound understanding, how to develop the law. And one of the things this centre has done is to encourage the development of the law in a way that shows the strength of the common law, but how it can be enriched, as he did in so much of his work, by the study and lectures he gave in other nations. We are influenced by what people who come here from overseas. We're profoundly grateful for that. And that achievement of Aleka's reflects exactly what he would want. Secondly, and I only want to take three respects, there's the young. I've had the privilege of going to some of the young maritime professionals' evenings, and it is remarkable to see the enthusiasm. And I've never met anyone quite like Michael Mustill, and I knew him from the time I first came to the bar for a long time thereafter, who had such enthusiasm of ensuring that the young benefited in every way from what he was able to do and what he was able to teach them. And the third respect, and this is profoundly important, is have fun. And it's no use being a lawyer without having fun is really awful. And we are privileged to be able to work in an area of great interest, of great importance. But our great additional privilege is to be able to enjoy it and to have fun. And my goodness me, haven't we had fun tonight? But also in the whole development of the centre, there's been tremendous fun. And what I would like you all to do now, because it's only fair we should do this, and I know you've had to sit down for a long time, but I'm going to give you the opportunity all to stand up. Can we drink Alika's health and thanks for everything she's done? Alika, thank you very, very much. And well done for this huge achievement.
My lords, distinguished guests, ladies and gentlemen, would you please welcome to the stage George Chivleris.
Hi, everybody. Just a few words before we just finish off with this great occasion. I came up here, I'm quite emotional about this whole scenario because I've actually lived the entire life of London Shipping Law Centre for the last 30 years. That's only the beginning, so don't be deterred, we haven't finished yet. But what I want to convey is, first of all, my extreme gratitude to Alika and the whole team of London Shipping Centre for all they've done. I think what Alika has done is, as was mentioned earlier, something which is close to being miraculous. For me, all I've done is that from the part of the shipping industry at large, which I've lived all my entire career, whether it's in the shipping business, the salvage business, the insurance business, I've been around the lot, as they say, and I've got a bit of scar tissue. And it's been a great pleasure being in this business. But first of all, it's so important to realize that with occasion like this, and with an organization like this, it's so important to go and bring the synergy required in the industry between the older generations who have their scar tissue and got the experience to convey to the younger generation, the younger ones who can be inspired by those who've been around for a while and actually can give that kind of message across or leave that message embedded in their soul. It wouldn't be correct to finish off this evening without referring to my concern about what's happening in the world at large right now. We have, literally a scale of perhaps war going on between Iran and Israel. We've got the situation in China, in Ukraine, and of course we don't want to divert from the celebration we have this evening. But I think we also have to be very, very concerned, very conscious of the fact there's nothing secure in this life. For the younger generation, all I can say is that for you who are here, and I'm very inspired by the fact that I can see a lot of the younger ones here, the only advice I can give is have faith, be daring, maintain childish enthusiasm, think out of the box, deter logic, and be inspired by those around you. That's the only message which actually I can give to literally to give what was mentioned earlier, the basic magical word of hope. Ladies and gentlemen, none of us here would be around without constantly having hope. On a final note, I'll quote an American philosopher by the name of Edwin Land. He happened to have invented the Polaroid camera. And I think one thing which is applicable today, because it's applicable to Aleka, which she actually did it, lock, stock and barrel, is the following. He mentioned the following. Never undertake a project in life unless it is manifestly important and nearly impossible. Aleka, that's what you did. Thanks from all of us. Hello. Hello. I came here to go and give you a lovely present.
Oh, thank you.
Part of the Line Achievement Centre. It's the least we could do.
Oh, thank you
You're a
very
glamorous
much.
woman, you've lived a glamorous life, and you're entitled to a glamorous present.
Thank you.
And look at what this is, so it's all from all of us. Yeah? Okay, Ladies and gentlemen, I'm a romantic Greek. How can I come up here without giving a beautiful necklace and a spire of jewelry? What else can I give? A certificate of confederacy.
What do you want to see?
Het is personal, in het mannenmessen. Hartstikke, it's the whole scenery.
Okay. Nice pearls. Thank you,
It's a
George.
pearl set anyway.
Thank you
Anyway.
very much.
Guys, thanks for having you. It's been a great evening. I don't think any of us will leave tonight without having a great smile on our face. And I say, this woman here, she's a real miraculous to work with. She can sometimes be, I don't think she can be as obnoxious or as unbearable as I can be. But on the other hand, you don't continue to call it the external dancer. You never give up. And that's what we all love you for. Thank you very much
I'm
indeed.
giving up now.
Oh, I keep more than that. Brilliant. You don't give up. You continue.
So, ladies and gentlemen, my last duty this evening is to say to you all, please enjoy the rest of the evening. And the card bar is now open. Thank you very much indeed.